The judge raised his hand before the clerk finished pressing play. "Stop the audio," he said, calm but firm, and the sound cut off mid-word. My stomach tightened as the room went quiet. The small courtroom smelled faintly like old paper and disinfectant. I kept my hands folded on the table in front of me, my phone face down beside a manila folder, exactly where my attorney had told me to leave it. I didn't move. The judge leaned forward in his chair. He wasn't looking at me. He was looking past me. "That voice," he said, tapping the edge of the bench with one finger, "does not belong to the petitioner." A few heads turned. Not all the way, just enough to feel it. My husband sat 2 tables over, shoulders squared, one leg crossed over the other like this was any other hearing. His lawyer's pen hovered above a legal pad, frozen. No one spoke. The clerk glanced at the screen, then back at the judge. "Your Honor?" "Rewind it 10 seconds, the judge said. The clerk did. The audio started again. A man's voice filled the room, low and steady, using my name, saying things I had never said, threatening things I would never threaten. The judge lifted his hand again. Silence dropped like a door closing. I stared at the wood grain of the table. I had memorized it over the last 3 months. Every nick, every scratch. It was easier than looking up. "Counsel," the judge said, turning slightly. "Whose voice is on that recording?" My attorney didn't answer right away. She slid a pen out of her folder and lined it up with the edge of her notebook. A small movement. "Careful." "That recording," she said evenly, "was submitted as evidence attributed to my client." The judge nodded once. Then he looked directly at my husband. "And yet," he said, "it appears to be a male voice." My husband shifted in his chair, just a little, the kind of movement you'd miss if you weren't already watching him. He didn't look at me. He looked at his lawyer. His lawyer cleared his throat. "Your Honor, we object to—" "I didn't ask for an objection," the judge said. His voice wasn't raised. That was worse. "I asked a question." The bailiff adjusted his stance near the wall. I could hear the faint creak of leather from his belt. Someone in the back row crossed their legs. The room was suddenly too full of sound. The judge waited. My husband finally spoke. "I don't recognize that recording." He said it quickly. Too quickly, like he'd practiced it. The judge didn't respond right away. He picked up a thin stack of papers from the bench and flipped one page, then another. The sound was slow, deliberate. "This audio file," the judge said, "was submitted as part of a sworn statement accusing the petitioner of making threatening calls. Is that correct?" "Yes," my husband said. "And you're telling the court," the judge continued, "that you don't recognize the voice on it." "That's correct." I felt my attorney's knee brush mine under the table, not reassurance. A warning to stay still. The judge looked down at the file again. "Clerk, how long is the full recording?" 2 minutes and 40 seconds, Your Honor." "Play another 10 seconds. The room filled again with the same voice, calm, controlled. Saying my name like it belonged to him, I swallowed. My throat felt dry, like I'd been holding my breath without realizing it. The judge lifted his hand. Silence. He sat back this time. His chair creaked softly. "That voice," he said, "is not unfamiliar to this court." My husband's lawyer finally put his pen down. The judge's eyes didn't leave my husband. "Have you ever made calls from your wife's phone?" "No," my husband said, this time slower. "Have you ever accessed her voicemail?" "No." "Have you ever represented yourself as her in any communication related to this case?" "No." Each answer landed heavier than the last. I could feel it in my chest, the way the air seemed to thicken. The judge closed the file. "I am stopping this hearing." The words hung there. No gavel, no drama, just a statement. "We will not proceed," he continued, "until the origin and identity of this recording are clarified." My husband's lawyer stood halfway out of his chair. "Your Honor, with respect." The judge raised his hand again. The same motion as before. Exact. Controlled. "I will issue an order," he said, "requiring submission of devices and logs related to this audio file." I did. He turned his gaze to me for the first time. "Miss Carter," he said, "did you make this recording?" I lifted my head. My voice felt like it had to travel a long way to get out. "No," I said. He studied my face for a moment. Not unkindly, not warmly either, like he was measuring something invisible. "Did you submit it?" "No." He nodded once. Then he looked back at my husband. "This court takes identity falsification very seriously," he said, particularly in matters involving custody. Unquote. The word custody landed like a weight. My hands tightened in my lap. I didn't unclench them. The judge glanced at the clerk. Mark this exhibit as disputed. Yes, Your Honor. The clerk typed quickly, keys clicking. Permanent. I am ordering a brief recess, the judge said. Counsel will remain available. He stood. Everyone else followed, chairs scraping softly against the floor. As the judge exited through the side door, the room buzzed with movement. Papers shuffled. Whispered conversations started and stopped. I stayed seated. My husband finally looked at me. Just for a second. There was no anger on his face, no panic, just calculation. Then his lawyer leaned in and whispered something I couldn't hear. My attorney touched my folder and slid it an inch closer to me. Inside were things we hadn't planned to use yet. Not today. The bailiff announced the recess. People stood. The room emptied in slow pieces. I flipped my phone face up for the first time. There was one new voicemail notification. I didn't open it. The recess lasted longer than I expected, long enough for the courtroom to empty and refill with a different kind of tension, the kind that settles in once people realize something has gone wrong and no one knows how far it will go. When we were called back in, I took the same seat, slid my chair in the same way, placed my hands on the table, and left my phone untouched, even though I could feel its weight through the wood. The judge returned without ceremony, sat down, and looked immediately at the clerk. "Play the first 30 seconds again," he said. The speaker crackled to life, and there it was again, my name in my husband's voice, careful and steady, as if he were reading off a script he'd written just for this room. The judge stopped it before the first sentence ended. "That's sufficient," he said. He turned to my husband's attorney. "Counsel, you stated earlier that your client does not recognize this voice." The attorney stood, buttoned his jacket, and nodded. "That's correct, Your Honor." The judge folded his hands. "Then explain to me how a recording containing a male voice, submitted under oath as the petitioner's, entered this court record." The attorney paused, glanced at my husband, then back at the bench. "Your Honor, at this time we would request an opportunity to review the source file and—" "You've had that opportunity," the judge said, not unkindly, just final. "This recording has been in your possession for weeks." My husband shifted, uncrossed his legs, crossed them again the other way. I noticed because he always did that when he was irritated, a small habit he never thought anyone picked up on. The judge's gaze moved to him again. "Mr. Carter," he said, "I want to be clear. You are accusing the petitioner of conduct that could materially affect custody. Do you understand the seriousness of that?" "Yes," my husband said. "Then answer the question," the judge replied. "How did this recording come to exist?" There was a pause. Not long, just long enough. "I received it," my husband said. "From where?" "From her voicemail." The judge's eyebrow lifted slightly. "You received it from her voicemail?" "Yes." "How did you access her voicemail?" My husband hesitated. His lawyer opened his mouth, then closed it. "We share accounts," my husband said. "Did you have her permission?" "At the time, yes." I felt my attorney's pen tap once against the table, a quiet sound but enough to ground me. The judge leaned back. "Miss Carter," he said, turning to me, "have you ever given your husband permission to access your voicemail?" "No," I said. My voice didn't shake. I focused on the edge of the bench instead of his face. "Have you ever left threatening messages on his phone?" "No." "Have you ever made any calls related to this case under someone else's name?" "No." The judge nodded slowly. He looked back at my husband. "Mr. Carter, the petitioner denies making this recording or granting access to her voicemail. You deny recognizing the voice. We have an audio file submitted under oath that does not match the identity it claims. Do you see the problem?" My husband's jaw tightened. "I believe she's lying," he said. The words landed flat. No one reacted. The judge waited a beat, then another. "On what basis?" he asked. "Based on her history," my husband replied. "Which is?" "Erratic behavior," he said. "Threats." "Threats that exist only in this recording," the judge said. "Yes." The judge turned to the clerk. "Do we have metadata for this file?" The clerk nodded. "Basic metadata, Your Honor." "Does it indicate the device used?" "Yes." The clerk looked at the screen. "It lists an iPhone, model matching the petitioner's." My husband exhaled, almost a sigh of relief. The judge didn't look impressed. "And does it indicate user access?" The clerk hesitated. It shows the file was accessed multiple times before submission. By whom? The account credentials are shared, the clerk said carefully. The judge steepled his fingers. Shared credentials are not shared voices, he said. He looked at my attorney. Counsel, have you reviewed this audio independently? Yes, Your Honor, she said, standing. And? It is not my client's voice. Do you have reason to believe it belongs to someone else? She didn't look at my husband when she answered. Yes. The judge's gaze sharpened. Explain. My client's phone records show periods of access when she did not have possession of her device, she said, including times when Mr. Carter was driving her vehicle. My husband's head snapped up. That's not relevant, his lawyer said quickly. It may be, the judge replied. He looked at my husband again. Did you ever have possession of your wife's phone? We lived together, my husband said. So yes. Did you ever record messages on it? No. Did you ever log into her voicemail? No. The judge exhaled slowly. I am not satisfied, he said. The room went still. I am ordering both parties to submit devices associated with this recording for independent forensic review, he continued. Phones, cloud accounts, and any linked systems. My husband's lawyer objected again. The judge didn't let him finish. This is not optional, he said. The integrity of this proceeding is at issue. He looked directly at my husband. If it is determined that evidence was falsified or identity misrepresented, this court will consider sanctions. The word sanctions echoed softly off the walls. I didn't move. My husband stared straight ahead, his face unreadable, but his hands were clenched now, resting flat on the table. The judge nodded to the clerk. Schedule an evidentiary review, he said. As soon as possible. Yes, Your Honor. He gathered his papers, paused, then added, Until then, no further testimony will be heard on this matter. He stood, signaling the end without a gavel. As people began to rise, I finally allowed myself to breathe out, slow and controlled. My attorney leaned toward me. We didn't plan on this happening today, she whispered, but it's happening. I nodded once. Across the room, my husband picked up his phone, checked the screen, then slipped it back into his pocket without looking at me. The bailiff announced the adjournment. Chairs scraped. Conversations started. I stayed seated for a moment longer, staring at the table, knowing that whatever came next would not be something he could talk his way out of. The days between the hearings settled into a tight, uncomfortable routine, the kind where everything looks normal from the outside, but every small action carries weight. I woke up at the same time, packed lunches the same way, drove the same route, but now every sound from my phone made my chest tighten. I kept it on the kitchen counter instead of my pocket, screen up, volume low, watching it like it might move on its own. My attorney called twice that first day, both times asking the same questions in slightly different ways. When had I last changed my voicemail password? Who had access to my car? Where was my phone during certain evenings months ago? I answered carefully, opening my calendar app, scrolling back through old entries, pointing at the screen as if she could see it through the line. Soccer practice. Late meeting. Grocery run at 9:30. Each detail felt like it mattered now. The next morning, a letter from Child Services sat half inside my mailbox, white envelope bent at the corner. I carried it inside without opening it, set it on the table, made coffee first, because that was my habit and I needed something to stay the same. When I finally slid a finger under the flap, the paper inside referenced threatening voicemail messages again. The same language, copied and pasted, but now it was paired with a date that made my stomach drop. A date when I'd been out of state for work. I folded the letter carefully and placed it back in the envelope, lining it up with the edge of the table, then took a picture of it with my phone and sent it to my attorney without a comment. She replied with a single word, "Good." At school pickup that afternoon, another parent asked me if everything was okay, her voice too gentle, her eyes lingering just a second too long. I said yes, smiled, reached for my child's backpack, and felt the zipper snag under my fingers. On the drive home, my phone buzzed once. Unknown number. I didn't answer. The voicemail icon appeared a moment later. I pulled into the driveway and sat there with the engine running, watching the garage door stay closed, listening to the tick of cooling metal. When I finally checked it, it was silent. No message. Just the record of a call that shouldn't have existed. That night, I logged into my voicemail settings, changed the password again, then logged out of every device, watching the list refresh until only my phone remained. My attorney forwarded me a document the next morning, a preliminary note from the court clerk flagging inconsistencies in the audio exhibit. I printed it, slid it into a folder, and placed it on the corner of my desk where I could see it while answering emails for work, my mouse moving, my other hand resting flat on the paper as if it might disappear if I looked away. 2 days later, my husband texted me for the first time since the hearing. Just one line, "We need to talk." I stared at the screen until it dimmed, then locked it without responding. That evening, as I was loading the dishwasher, my attorney called again, her voice lower this time. She asked if I remembered my husband borrowing my car late last year, if I remembered him complaining about Bluetooth issues, if I remembered coming home to find my phone not where I'd left it. I leaned against the counter, towel in my hands, and images surfaced that I'd brushed off before. Him sitting in the driver's seat with the engine off, phone connected, saying he needed privacy for a call. Him handing my phone back with the screen dark, telling me the battery was low. I told her all of it. She was quiet for a moment, then said the court had ordered carrier logs, not just for calls but for device connections. "This is going to get technical," she said, "but it's also going to get very simple." The next morning, a courier arrived with a padded envelope addressed to me from the court, requesting device submission by the end of the week. I signed for it, my name looping across the screen, and noticed my hand didn't shake. I placed my phone inside the envelope later that night, sealed it, then opened it again to check one last thing. In the access history, there it was, a login time that matched the date on the Child Services letter. A location ping I'd never noticed before. My attorney confirmed it an hour later. "That's not you," she said. "No," I replied, looking at the map, the small blue dot hovering over a parking lot I'd never been to. On the day of submission, I carried the envelope into the courthouse myself, passed it across the counter, and watched the clerk log it in, her keyboard clicking fast and efficient. Outside, I saw my husband in the parking lot, leaning against his car, phone pressed to his ear. He saw me and turned away, pacing, one hand in his pocket. I didn't stop. I drove home, pulled into the garage, and sat there for a moment before getting out, listening to the echo of the door closing behind me. That night, my attorney emailed me late, subject line empty, just a scanned page attached. It was a call log, highlighted in yellow, showing repeated access during times I'd been asleep, times when my phone had been charging on my nightstand. I stared at the timestamps, the pattern forming without anyone explaining it, and understood that the next time we were in that courtroom, the question wouldn't be whether the voice was his, but how long he thought he could keep pretending it wasn't. By the time the court scheduled the evidentiary review, the rhythm of my days had shifted in small, precise ways, like furniture moved an inch at a time until the room felt unfamiliar. I stopped charging my phone on the nightstand and left it on the dresser across the room, screen facing the wall, cable unplugged when I slept, not because it mattered anymore, but because habits linger even after the danger changes shape. My attorney sent over a timeline, a simple spreadsheet with dates in one column and activity in another. Nothing dramatic until you read it straight down and realized how often my phone had been active when I hadn't been. I printed it, slid it into the same folder I'd been carrying since the first hearing, and brought it with me to work, setting it under my keyboard like a paperweight. At lunch, I sat in my car instead of the break room, ate a sandwich with one hand, scrolled through old photos with the other, looking for gaps, moments when my phone had been somewhere my memory wasn't. That afternoon, my husband's attorney emailed mine requesting a continuance, citing scheduling conflicts, and when my attorney forwarded it to me, she added a single sentence, "They're trying to buy time." I nodded to myself even though she couldn't see it. That night, I received another voicemail notification, this one time-stamped while I was standing at the stove stirring pasta, my phone in plain sight on the counter. I didn't open it. I took a screenshot of the notification instead, capturing the time, the number, the absence of a message, then turned the phone face down and finished cooking. The next morning, my attorney called early and asked me to walk through the house room by room, naming where my phone usually was at certain times of day: kitchen counter, passenger seat, gym locker, bedside table. As I spoke, she typed, occasionally asking me to repeat something, to be exact. When we got to the garage, she stopped me. "Did your husband ever sit in the car with the engine off?" she asked. I pictured it immediately, him leaning back, Door closed, phone connected, saying he needed to take a call privately. "Yes," I said. "Often." She exhaled softly. Later that week, the phone carrier records came in, pages of them, dense with numbers and timestamps. But one section stood out, highlighted by the analyst: repeated Bluetooth connections to a single vehicle during outgoing calls logged under my voicemail account. The vehicle was registered to my husband. The dates matched the spreadsheet. The spreadsheet matched the child services letter. Nothing needed to be explained. It lined up on its own. I met my attorney at her office that Friday, sat across from her desk, watched as she slid the folder toward me, the same sliding motion, controlled, deliberate. "This is where it changes," she said, tapping the edge. "Not emotionally, legally." I asked her what would happen next. She said the court would reconvene, that an audio expert would testify, that the judge would listen. I asked if my husband would keep denying it. She paused, then said, "He probably will." On my way out, I passed my husband in the parking garage, his car parked crookedly between the lines, his trunk open as he rearranged something inside. He looked up when he saw me, closed the trunk too hard, and said my name like it was a question. I didn't answer. I walked past him, keys in my hand, the sound of them louder than it needed to be. That night, he sent another text, longer this time, talking about misunderstandings, about how things had gotten out of hand, about how the court didn't need to be involved in personal matters. I didn't respond. I forwarded it to my attorney and turned my phone off. The weekend passed quietly. Too quietly. Like the pause before weather changes. On Monday morning, a courier delivered a sealed envelope to my door. The forensic analyst's preliminary report inside, marked confidential, stamped with a date for the hearing. I sat at the kitchen table, the same spot, and read it once. Then again, my finger tracing the line that stated the probability match between the voice on the recording and my husband's known speech patterns. 98%. I folded the report and slid it into the folder, feeling the weight increase just slightly. At work, I couldn't concentrate, found myself rereading the same email, my eyes drifting to the clock, counting down hours I couldn't speed up. When the day finally ended, I drove home slowly, parked in the garage, and sat there with the engine off, remembering how many times he'd done the same thing for reasons that made sense then. Inside, I laid out what I'd need for the hearing: ID, folder, phone, charger. I placed them neatly by the door, then stood there for a moment, listening to the quiet of the house, aware that the next time I heard his voice, it would be through speakers again, in a room where silence carried consequences. The week compressed into a narrow corridor of deadlines and small decisions that all pointed in the same direction, and by the time the day of device submission arrived, it felt less like a choice and more like a formality that had been delayed. I drove to the courthouse early, parked farther away than usual, and walked the rest of the way with the folder tucked under my arm, the weight familiar now, reassuring in its own quiet way. Inside, the clerk checked my ID, slid a plastic tray across the counter, and asked for my phone. I placed it there, screen dark, cable wrapped neatly, and watched as she logged the serial number, the sound of the keyboard steady and impersonal. She sealed it in an evidence bag, pressed a sticker closed, and set it aside with a nod, and for the first time in months, my hands were empty. Outside, the air felt sharper, colder, and I stood for a moment on the courthouse steps, adjusting to not feeling the phone's vibration, the phantom buzz that had followed me everywhere. My attorney called an hour later to confirm receipt and told me my husband had not yet complied, that his lawyer was pushing back, citing privacy concerns and work obligations, that the judge was not pleased. I could hear papers moving on her end, the scrape of a chair. "The court ordered it," she said. "Delay doesn't help him." That afternoon, child exchange was scheduled at the usual place, the grocery store parking lot, neutral territory with cameras and witnesses. I arrived early, leaned against my car, and watched people load bags and carts, the ordinary rhythm of a Tuesday afternoon unfolding around me. My husband pulled in late, parked crookedly, and stayed in the car longer than necessary, hands on the steering wheel, staring straight ahead. When he finally stepped out, our child hopped down, backpack swinging, and ran toward me without hesitation. My husband hovered a few feet away, cleared his throat, and said, "We need to coordinate." I didn't answer. I buckled the seatbelt, closed the door, and drove away, checking the mirror once to see him standing there alone, phone already in his hand. That night, my attorney forwarded me an email thread from opposing counsel, their tone shifting from confident to careful, words like cooperate and clarify appearing where accusations used to be. She followed it with a brief note. He submitted his phone. Partial. I stared at the word partial, feeling something tighten. The next day, the court issued a notice scheduling the evidentiary review for the following week, and with it came an order restricting my husband's contact with shared accounts pending review. The notice arrived by email and certified mail, the envelope heavy in my hands, official in a way that left little room for interpretation. I placed it on the counter, smoothed it flat, and took a photo before filing it away. My husband texted that evening asking to talk again, this time softer, apologetic, saying the court was overreacting, that mistakes had been made on both sides. I didn't respond. Instead, I opened my laptop, logged into my email, and changed passwords one by one, watching the confirmation messages stack up in my inbox. On Thursday, my attorney called with an update, her voice clipped. The analyst found deleted files, she said. Recovered audio fragments. I sat down at the kitchen table, the same chair, the same spot, my fingers curling around the edge. From where? I asked. From his device, she replied. Time-stamped during periods you were documented elsewhere. I closed my eyes briefly, then opened them, focusing on the grain of the wood. What does that mean for the hearing? I asked. It narrows things, she said. It also explains why he resisted. That night, I couldn't sleep. Lay in bed listening to the house settle, every creak and hum amplified without the familiar glow of my phone nearby. I thought about the garage, the car, the quiet moments I'd ignored because they hadn't felt important at the time. On Friday morning, another courier arrived, this one carrying a sealed packet addressed to my attorney, requiring my signature for acknowledgement. I signed, watched him walk back down the driveway, and stood there a moment longer, the paper cool under my palm. The weekend stretched thin, filled with errands and routines done deliberately, slowly, as if moving too fast might tip something over. On Sunday evening, my attorney emailed again, subject line simply update, attaching a summary of findings, access logs, Bluetooth connections, recovered audio, all converging on the same conclusion without stating it outright. I read it once, then forwarded it to a secure folder, closing the laptop with a soft click. The night before the hearing, I laid out my clothes, the folder, my ID, and a borrowed phone my attorney had arranged for me to use temporarily, its unfamiliar weight a reminder that this wasn't over yet. I stood in the doorway for a moment, listening to the quiet, knowing that the next day would pull everything into the open, and that the space my husband had relied on, the gray area where denial lived, was shrinking fast. The morning of the evidentiary review arrived without drama, just a gray sky, and a feeling of pressure that sat behind my ribs as I drove to the courthouse, with the borrowed phone resting in the cup holder like it didn't quite belong to me. I parked, checked my reflection in the rearview mirror, and took a breath before getting out, the folder tucked under my arm again, heavier now with reports and logs that no longer felt theoretical. Inside, the hallway outside the courtroom was quieter than before, fewer people waiting, fewer conversations, and when my attorney arrived, she didn't waste time on small talk, just nodded and asked if I was ready, a question that didn't really require an answer. We took our seats, the same tables, the same layout, but the mood had shifted, less accusation, more anticipation. When the judge entered, everyone stood, then sat, and he went straight to the point, eyes moving from one table to the other. This hearing is limited, he said. We are here to address evidence integrity. The clerk swore and the forensic analyst, a man with a neutral expression and a laptop bag placed carefully at his feet, and when he began to speak, his voice was steady, precise, carrying easily through the room. He described the process first, how devices were imaged, how data was recovered, how voice patterns were compared, not with flourish but with method, and I watched the judge listen, chin resting on his hand, eyes focused. The analyst opened his laptop, connected it to the court system, and a waveform appeared on the screen, lines and spikes that meant nothing to me until he explained that consistency, rhythm, and frequency mattered more than words. He played a brief clip, not the full recording, just a fragment, and stopped it almost immediately. That is sufficient, the judge said, echoing his own words from weeks earlier. The analyst nodded and continued, explaining how the same vocal markers appeared across multiple recovered files, some deleted, some altered, all accessed from the same device. He stated the probability match calmly, without emphasis, and when he said 98% again, the number felt less like a shock and more like confirmation of something that had already settled. My husband's lawyer objected, questioned methodology, raised concerns about sample size, and each time the analyst answered with specifics, dates, timestamps, device IDs, his cursor moving across the screen to show exactly where the data came from. The judge asked a few questions himself, pointed ones, about access times and location data, and the analyst responded by pulling up a map, small dots clustered around places I recognized: the grocery store parking lot, the garage near our old house, the office complex where my husband worked. No one looked at me. They didn't need to. My husband sat rigidly, hands clasped, staring straight ahead, his face set in a way I'd seen before, the look he wore when arguing facts instead of feelings. When it was his attorney's turn to cross-examine, the tone shifted, sharper, but the answers didn't change, and after a few minutes the questions slowed, then stopped altogether. The judge leaned back, steepled his fingers, and looked at my husband directly. "Mr. Carter," he said, "do you have any explanation for the presence of these files on your device?" My husband's lawyer started to speak, but the judge raised his hand, that same controlled motion, and waited. My husband swallowed. "I don't know how they got there," he said. The judge nodded once, not in agreement but acknowledgement. "Do you deny accessing your wife's voicemail account during the periods identified?" "Yes," my husband said. "Despite the access logs?" "Yes." The judge glanced at the analyst, then back at my husband. "Do you deny recording audio using her credentials?" "Yes." The judge exhaled slowly. "Very well," he said. He turned to my attorney. "Counsel, do you wish to add anything?" She stood, adjusted the folder in front of her, and said only that the evidence spoke for itself, that the pattern was clear, that the implications for the custody matter were serious. She didn't raise her voice. She didn't need to. The judge nodded again and made a note, pen scratching softly against paper. "I am finding," he said, "that there is sufficient evidence to establish misuse of access and falsification of recordings." The words landed quietly but firmly, like a door closing. My husband's head turned slightly, just enough to show the tension in his jaw. The judge continued, outlining next steps, sanctions to be considered, referrals to be made, his tone procedural but unmistakably final. He ordered the clerk to enter the findings into the record, and the sound of typing filled the room, each keystroke another mark that couldn't be undone. As the hearing concluded, the judge looked at me briefly, not with sympathy, but with something closer to recognition, then stood, signaling the end. People rose, chairs scraped, and the analyst packed up his equipment, careful and methodical. My attorney leaned toward me and whispered that this was the no-denial point, that from here forward everything would be about consequences, not questions. Across the room, my husband remained seated for a moment, longer than everyone else, staring at the table, then stood abruptly and gathered his things, his movements sharp. He didn't look at me as he walked out. I stayed seated until the room thinned, then stood, feeling lighter and heavier at the same time, aware that what had been private manipulation was now documented fact. In the hallway, my attorney paused and said the next hearing would address custody directly, armed with this record, and as we walked toward the exit, I realized that the silence I'd been carrying for months had finally shifted. No longer something I was trapped inside, but something that now followed him instead. The courtroom filled more slowly than it had the first time, the benches creaking as people settled in with the awareness that this wasn't going to be routine, and when I took my seat I noticed how many eyes lingered before looking away, the kind of attention that doesn't feel curious so much as cautious. My attorney placed the folder between us and slid it an inch forward, the familiar motion signaling that this was the moment the private details crossed fully into public space. When the judge entered, the room rose and fell again, and he didn't bother with preliminaries, his gaze steady as he reminded everyone that findings from the evidentiary review were now part of the record. The clerk cued the audio again, and this time the judge allowed it to play a few seconds longer, long enough for the voice to register, long enough for the discomfort to ripple through the room as people recognized that what they were hearing didn't match the person being accused. He stopped it with the same raised hand, then nodded to the forensic analyst, who stood, adjusted his glasses, and addressed the court in plain language, explaining that the voice print analysis had been completed, that multiple samples had been compared, that the probability match exceeded 98%. He didn't look at my husband when he said it, but everyone else did, a subtle shift of heads that felt louder than any sound. My husband's lawyer objected again, quieter this time, more out of habit than hope, and the judge overruled it without looking up, his pen moving across the page. The analyst continued, describing how the recovered files aligned with access logs, how Bluetooth connections placed the device in specific locations at specific times, and as he spoke, the clerk displayed a timeline on the screen, dates and times stacked in neat rows that made the pattern impossible to miss. I kept my hands folded, my eyes on the table, letting the facts occupy the room without adding anything to them. When the analyst finished, the judge thanked him and turned to my husband, his expression neutral but firm. "Mr. Carter," he said, "this court has heard testimony establishing that the voice on the recording submitted under your wife's name is yours." My husband stood abruptly, his chair scraping, and for a second it looked like he might speak over the judge, but he stopped himself, his lawyer touching his arm in a gesture that came too late. "Do you dispute the analyst's findings?" the judge asked. "Yes," my husband said, his voice tight. "On what basis?" the judge pressed. "I don't accept the methodology," he replied, words chosen carefully, like they'd been rehearsed. The judge nodded once. "The court does," he said, and the room seemed to exhale collectively. He went on, stating for the record that the submission of falsified evidence constituted a serious violation, that the implications for the custody matter were significant, and that the court was halting any further testimony on accusations stemming from the disputed recordings. The clerk typed steadily, each keystroke another witness to what was happening. My husband's lawyer attempted to redirect, to argue intent, to suggest misunderstanding, but the judge raised his hand again, the same motion, and said, "That will be addressed later," in a tone that left no doubt about the order of things. He then addressed the room, reminding everyone that family court relied on truthfulness, that manipulation of evidence undermined the process, and that consequences would follow. I felt my attorney's knee brush mine again, this time not a warning, but an acknowledgement that this was landing exactly where it needed to. Behind us, someone shifted on the bench, a whisper cut off mid-syllable, the kind of silence that carries weight because it's shared. The judge called a brief recess, not to pause the momentum, but to let the record settle. And as he stood, he looked directly at my husband, his expression unreadable. The bailiff announced the recess, and the room broke into low murmurs, people standing, stretching, stepping into the aisle, but the energy had changed. The accusations that once hovered now pinned down by documented fact. My husband remained standing, staring at the screen where the timeline still glowed faintly, his jaw set, his hands clenched at his sides. When he finally turned, he didn't look at me, just walked out quickly, his lawyer following a step behind, whispering urgently. I stayed seated, breathing evenly, aware of the looks, the subtle recalibration happening around me as people processed what they'd just witnessed. My attorney leaned in and murmured that the judge had effectively stripped the recordings of any credibility, that this was the public exposure point, that from here, the narrative shifted. When the bailiff signaled that the recess was ending, I straightened in my chair, knowing that whatever came next would be built on what had just been said out loud, in this room, with witnesses. When the recess ended, the courtroom felt smaller, like the air had been pressed out of it and hadn't quite returned, and as everyone took their seats again, the usual shuffling was muted, people careful with their movements, aware they were sitting inside something that mattered. The judge resumed without delay, stating that the court would now address procedural consequences, not arguments, and his tone made it clear this was not an invitation for debate. He directed the clerk to summarize the findings already entered, and as she read them aloud, her voice even and precise, I watched my husband out of the corner of my eye, the way his shoulders stiffened with each line, the way his foot tapped once before going still. When the clerk finished, the judge folded his hands and said, "Given the established misuse of access and falsification of evidence, this court is imposing immediate restrictions." He listed them one by one, suspending the contested accusations, ordering supervised communication only, mandating compliance reviews, each item landing with a dull thud that echoed in the silence. My husband's lawyer stood to object, but the judge stopped him with a look, reminding him that these were interim measures, not findings on custody, though the implication hung in the room like a held breath. The judge then addressed my husband directly, asking whether he understood the restrictions, and when my husband answered yes, his voice strained. The judge nodded and instructed him to remain seated after the hearing. That detail alone sent a ripple through the benches, a quiet acknowledgement that something irreversible was unfolding. As the judge moved on to scheduling, setting dates and outlining expectations, the guardian ad litem requested clarification on the impact of the findings, and the judge responded that credibility would be assessed accordingly, his words careful but unmistakable. I kept my eyes forward, my hands steady, feeling the attention shift again, not toward me, but toward the absence of denial, the lack of alternatives left. When the judge finally adjourned the session, the bailiff's announcement sounded louder than before, chairs scraping sharply as people stood, conversations starting and stopping, as if no one was sure what was appropriate to say. My husband remained seated as ordered, his lawyer leaning in close, whispering urgently, while the bailiff stood nearby, arms crossed, watching. I gathered my things slowly, the folder sliding into my bag with a soft thump, and stood, aware of the path I would have to take past the benches. As I walked, I caught fragments of murmured conversation, words like recording and voice, and that's serious, not directed at me but hanging in the air nonetheless. Outside the courtroom, the hallway buzzed, attorneys checking phones, clients speaking in hushed tones, and when my attorney joined me, she guided me a few steps away, her hand light on my elbow. "This is where it gets uncomfortable for him," she said quietly. "Publicly." We paused near a window, sunlight cutting across the floor, and through the glass doors I could see the parking lot, people coming and going, unaware of what had just been formalized inside. A few minutes later, my husband emerged with his lawyer, their conversation tense, his gestures sharp, and when he spotted me, he slowed, his expression shifting into something measured, almost pleading. He started toward me, but his lawyer caught his arm, shaking his head, reminding him of the restrictions, and the moment passed, leaving him standing there, jaw tight, eyes flicking away. The bailiff appeared again, guiding him toward a different exit, and the separation felt symbolic, a physical manifestation of boundaries that had finally been enforced. As we walked toward the elevators, my attorney explained the next steps, the reports that would be filed, the way the court's perception had shifted, but her words faded into the background as I processed the quiet fallout, the way people moved around me with a new awareness. In the elevator, a woman I didn't recognize nodded at me, not sympathetically, just acknowledging, and when the doors opened, the moment was gone. Outside, the air felt different, lighter and heavier all at once, and I stood for a moment on the steps, adjusting my bag, grounding myself in the solid feel of stone under my feet. My attorney asked if I was okay, and I answered yes, because in that moment it was true, even if the word meant something different than it used to. Across the plaza, I saw my husband again, speaking on his phone, pacing, his movements sharp and contained, and for the first time, the sight didn't pull at me, didn't demand a reaction. I turned away, walked toward my car, and as I drove off, I realized that the social pressure he had relied on, the ability to shape narratives quietly, had shifted in front of witnesses, and that the discomfort I'd carried for months was now something he would have to navigate in public without my silence to cushion it. After the hearing, everything moved faster. Not in big visible ways, but in paperwork, notifications, and quiet confirmations that arrived without ceremony and stacked up until the direction was unmistakable. The court issued a written summary of the restrictions the next morning, and when my attorney forwarded it to me, I read it at the kitchen table, with a mug cooling beside my hand, each paragraph tightening the frame around what could and could not be argued anymore. The language was careful, neutral, but the meaning was clear. The recordings were no longer a question, they were a fact, and the case was now about what flowed from that fact. My attorney asked me to come in that afternoon, and when I arrived, she had a new folder waiting, thicker than the last, tabs labeled with dates instead of topics. She slid it across the desk, the same deliberate motion, and said this was consolidation, the phase where everything that had been scattered got aligned. We went through it piece by piece, not lingering, just confirming. iCloud access logs showing repeated logins from a device registered to my husband during hours when my phone had been stationary. A carrier report tying outgoing voicemail activity to Bluetooth connections in his car. A recovered text message screenshot, time-stamped weeks before the first hearing, where he told a friend he had handled the calls and that I wouldn't be a problem much longer. I felt my jaw tighten at that one, not in anger but recognition, the casual confidence of it, the assumption that it would never be seen. My attorney noted which items would be formally submitted and which would be held back, not because they were weak, but because timing mattered, because some things were more powerful when introduced later. On my way out, her assistant handed me copies to review at home, and as I placed them in my bag, I noticed how routine the process felt now, like I'd crossed into a different stage where shock had been replaced by logistics. That evening, my phone buzzed with an alert from the temporary device I was using, an email from the court confirming receipt of additional exhibits, and I read it standing in the hallway, coat still on, before setting the bag down and kicking off my shoes. My husband didn't contact me directly anymore, but his presence lingered in indirect ways, a mutual acquaintance asking vague questions, a message from his sister about keeping things civil, each one an attempt to test the edges of the new boundaries. I didn't respond. I forwarded what mattered to my attorney and let the rest sit unanswered. 2 days later, she called with a clipped update. The Guardian ad litem had reviewed the consolidated evidence and was revising their recommendation. She didn't elaborate over the phone, just said it was significant and that the written report would be filed before the next hearing. I thanked her and hung up, then stood by the window for a moment, watching a delivery truck idle across the street, aware of how strange it was that something so consequential could feel so quiet. The revised report arrived that weekend, delivered electronically and by mail, and I opened it slowly, reading the conclusion twice to make sure I wasn't misinterpreting it. The language was measured, but the shift was unmistakable. Concerns previously attributed to me were now attributed to manipulation and misrepresentation by my husband, with specific reference to falsified communications. I placed the pages on the table, aligned them carefully, and took a photo for my records, then sat back, letting the chair creak under my weight. On Monday, my attorney and I met again to prepare for the next phase, and she explained how the court would likely proceed, how credibility assessments would factor into custody determinations, how the judge would have little patience for arguments that ignored the established record. She also mentioned, almost in passing, that opposing counsel had reached out informally, asking about potential resolutions. The word resolution hung there, unfamiliar, not because it was hopeful, but because it signaled a recognition on their side that the ground had shifted. That afternoon, as I was leaving her office, I ran into my husband in the lobby, an unavoidable convergence of timing and space. He looked thinner, more drawn, his suit slightly rumpled, and when he saw me, he hesitated, then nodded stiffly, a gesture that felt more reflex than intention. I nodded back, brief and contained, and continued toward the door without slowing. Outside, I paused to adjust the strap of my bag, the folder inside pressing against my side, and felt a quiet steadiness settle in. The narrative he had tried to build had collapsed under its own weight, replaced by documentation and timelines that didn't argue, didn't plead, just existed. That night, as I reviewed the final exhibit list my attorney had sent, I noticed how little of it relied on interpretation, and how much relied on simple alignment of facts, dates, and actions. It wasn't dramatic, it was thorough. And as I closed my laptop and turned off the light, I understood that the next time we were in court, the focus wouldn't be on uncovering anything new, but on acknowledging what was already there, on deciding consequences in the open, with nowhere left for his voice to hide behind mine. The final evidentiary hearing drew a larger crowd than the others, not because it had been advertised or dramatized, but because word travels quietly in places like family court, and by the time I arrived that morning, there was already a low hum in the hallway, attorneys speaking in clipped tones, clients sitting straighter than usual. I took my seat beside my attorney, placed the folder on the table, and rested my hands on top of it, feeling the familiar edge press into my palms. The judge entered on time, acknowledged the room, and stated plainly that this session would address the consolidated exhibits and any remaining disputes regarding their origin. The clerk cued the final audio file, the one my attorney had held back until now, and when it played, it wasn't longer or louder than the others, just clearer, stripped of context and excuses, my husband's voice instructing, correcting, rehearsing, using my name as if it were a tool. The judge let it run its full length this time. No raised hand, no interruption, and the silence that followed felt heavier because of it. He turned to the clerk and asked for the metadata to be displayed, and as the screen filled with timestamps, device IDs, and location markers, the analyst confirmed what the record already showed. The file had been created on my husband's phone, edited twice, and uploaded through my credentials during a period when my phone had been stationary and unused. My husband's lawyer rose slowly, objected on procedural grounds, suggested contamination, suggested coincidence, but the judge listened only long enough to shake his head. "The court finds the chain of custody intact," he said, and directed the clerk to enter the exhibit in full. The sound of typing echoed again, steady and final. The guardian ad litem requested permission to speak, and when granted, summarized their revised position, noting that the pattern of impersonation undermined prior concerns attributed to me and raised serious questions about my husband's conduct and credibility. My husband stared straight ahead, his face rigid, his hands clenched together so tightly his knuckles whitened. The judge thanked the guardian, then addressed my husband directly, his voice even but unmistakably firm. "Mr. Carter," he said, "you submitted evidence under oath that you knew or should have known was falsified." My husband opened his mouth, then closed it, his lawyer stepping in to argue intent, stress, misunderstanding, anything that might soften the impact, but the judge raised his hand, the same precise motion that had become a kind of punctuation in this case. "Intent will be addressed separately," he said. "The fact of falsification is established." He went on to state that the court was amending the record to reflect the impersonation, that any findings previously based on the disputed recordings were vacated, and that this amendment would be considered in all subsequent determinations, including custody. I felt my attorney's hand briefly touch my arm, grounding, then withdraw. The judge paused, looked out over the courtroom and said, "This court does not tolerate manipulation of its process," his gaze returning to my husband, "particularly when it involves a parent and a child." The words settled without theatrics, no raised voices, no gavel, just acknowledgement. He then outlined the immediate consequences: referral for further review, sanctions to be determined, and a clear directive that any further attempts to misrepresent communications would be met with swift action. The clerk recorded each point, the screen updating in real time, the official record reshaping itself line by line. My husband's lawyer attempted one last objection, quieter now, almost perfunctory, and the judge overruled it without comment. When the judge asked if there was anything further, no one spoke. The silence stretched, uncomfortable and undeniable, until he nodded once and said the matter was concluded. As he stood to leave, he addressed me briefly, confirming that the court recognized the harm caused by the impersonation and that the amended record would reflect that recognition. It wasn't sympathy, it was acknowledgement, and it mattered more. The bailiff announced the end of the session, chairs scraping as people stood, the room exhaling again, but this time the release felt different, heavier with consequence. My husband remained seated for a moment, staring at the table as if the grain might offer an alternative explanation, then stood abruptly, gathering his things with sharp movements. He didn't look at me. He didn't need to. The record no longer depended on what he said or didn't say. As I packed my folder away, the finality of it settled in, not as relief exactly, but as a quiet certainty that the last piece of evidence had landed where it was meant to, in the open, with witnesses, leaving nothing ambiguous behind. The courtroom was fuller than it had been at any point during the case, not because anything new was being presented, but because people understood this was where the weight of everything already said would finally settle, and when I took my seat, I could feel the awareness in the room, the shared understanding that something irreversible was about to be spoken out loud. The judge entered, acknowledged the room, and went straight to the matter at hand. His voice steady as he stated that the purpose of the session was to address consequences arising from the court's findings, not to revisit evidence or argument. He directed the clerk to read the amended record summary, and as she did, her voice neutral and precise, the words identity falsification and misuse of access echoed in a way they hadn't before, stripped of abstraction now that they were official. My husband sat rigidly at his table, shoulders tight, eyes fixed forward, his lawyer unusually still beside him. When the clerk finished, the judge folded his hands and looked directly at my husband, holding his gaze for a moment longer than usual. "Mr. Carter," he said, "this court has determined that you deliberately submitted falsified communications under your wife's identity in an attempt to influence custody proceedings." He paused, letting the sentence stand on its own. "That conduct strikes at the integrity of this court." My husband shifted, his chair creaking softly, and opened his mouth, but the judge raised his hand, that now familiar motion signaling that this was not a dialogue. "You were given multiple opportunities to correct the record," the judge continued. "You denied involvement. You maintained those denials after forensic confirmation." The judge's tone never sharpened, but the effect was sharper because of it. "As a result," he said, "the court is issuing the following findings and orders." He listed them one by one, each item precise and procedural, yet devastating in its accumulation. A formal finding of credibility, failure, dismissal of prior allegations against me tied to the falsified recordings, referral of the matter for further review regarding perjury and misuse of electronic communications, and a directive that these findings be considered in all custody determinations moving forward. The clerk typed steadily, the sound filling the room as each consequence became permanent. My husband's lawyer stood to speak, his voice measured, attempting to frame the behavior as panic, as poor judgment under stress, but the judge stopped him again, not abruptly, just decisively. "Intent does not erase impact," he said, "and it does not restore trust." He turned his attention to custody, stating that the court could not ignore the implications of a parent who would impersonate the other to gain advantage, that such behavior raised serious concerns about judgment and boundaries. My husband's face had gone pale, the color draining slowly as the words accumulated, and when the judge asked if he understood the orders being issued, my husband answered yes, his voice low, barely carrying. The judge nodded once and continued, outlining immediate custody adjustments pending final determination, the conditions clear, the structure firm. There was no dramatic pause, no flourish, just the quiet dismantling of the narrative my husband had tried to build, replaced with findings that required no interpretation. When the judge finished, he looked out over the courtroom, then back at my husband, and said, "This matter did not become public because of accusation. It became public because of proof." The sentence landed heavily, a kind of quiet humiliation that drew no gasps, no whispers, just stillness. He then turned to me, confirming that the court recognized the harm caused by the impersonation and that the record now reflected that recognition fully. I met his gaze briefly and nodded, the gesture small but steady. The bailiff stood a little straighter as the judge concluded, announcing that the orders were effective immediately and that further proceedings would be scheduled as required. When he stood to leave, the room followed, chairs scraping softly, people shifting with the knowledge that something significant had just ended. My husband remained seated for a moment after everyone else rose, staring down at the table, his hands resting flat now, no longer clenched, as if the effort of holding everything together had finally drained out of him. When he stood, it was slower, his movements careful, his lawyer leaning in to speak quietly, urgently, but whatever was said didn't change the fact that the room had already moved on. As I gathered my things, sliding the folder into my bag, I felt no rush of triumph, no surge of emotion, just a grounded sense that the truth had been placed where it could no longer be twisted. As I walked out past the benches, the looks I received were different from before, not curious or doubtful, but resolved, the kind that comes after something has been named clearly. Outside the courtroom, the hallway buzzed briefly, then thinned, and when the doors closed behind me, the sound echoed softly, marking the end of a chapter that had been forced into the open under fluorescent lights and recorded keystrokes. The weeks after the final hearing unfolded without spectacle, the way real consequences usually do, through emails, revised schedules, and small changes that quietly rewired my days. The court's written orders arrived first by email, then by mail, thick envelopes that felt heavier than their pages, and I read them at the kitchen table with the window open, the sound of traffic outside grounding me in the ordinary world that had kept going while everything else narrowed. Custody terms were reset, temporary on paper but firm in practice, outlining times, locations, supervision requirements, and communication boundaries so specific there was no room left for interpretation. I signed where required, scanned the pages, sent them back, and filed copies in the same folder that had carried me through every step, sliding it into a drawer that I didn't open again for a while. The first exchange under the new terms happened on a Saturday morning, earlier than usual, the parking lot nearly empty, the air cool enough that I kept my jacket zipped. A court-appointed supervisor stood a few feet away, clipboard tucked under her arm, neutral and observant. My husband arrived on time, which alone felt different, and when he stepped out of his car, his movements were careful, restrained, his eyes flicking briefly toward the supervisor before settling somewhere past me. There were no words exchanged beyond what was required, no attempts to explain or argue, just the mechanics of the transfer carried out under watchful eyes. When it was over, I buckled the seatbelt, checked the mirror, and drove away, the familiar route feeling slightly altered, like a road after construction where everything is technically the same but no longer moves the way it used to. At home, I unpacked groceries, folded laundry, answered emails, the ordinary tasks carrying a steadiness that had been missing for months, and when my phone buzzed, it was a calendar reminder, not a voicemail, not an unknown number. I changed nothing else that day, trusting the routine to hold. Over the next few weeks, the fallout continued quietly, reports filed, recommendations updated, the Guardian ad litem's final assessment arriving with language that mirrored what had already been said in court, measured but decisive. Friends who knew only fragments reached out cautiously, asking how things were going, and I answered simply, truthfully, without details, because the need to convince anyone had evaporated along with the accusations. My attorney called less frequently now, our conversations shorter, focused on logistics rather than defense, and during one call she mentioned that opposing counsel had withdrawn a prior motion entirely, the implication clear enough that neither of us commented on it. One afternoon, I received notice that my husband's access to certain shared accounts had been formally terminated, the email confirming what had already become practice, and I logged in to verify, watching the permissions list refresh until his name disappeared. I sat back in my chair and let the screen dim on its own. The last required court appearance was administrative, brief, and unremarkable. The judge confirming compliance, the clerk recording acknowledgments, no raised hands this time, no audio played, just closure documented in neat lines of text. As I left the building, the automatic doors sliding shut behind me, the sound echoed softly, familiar now but no longer charged. Life adjusted itself around the new boundaries in subtle ways, mornings quieter, evenings predictable, the constant vigilance loosening its grip, and when I caught myself reaching for my phone out of habit, expecting something to be wrong, I noticed the absence and let it pass. One evening, weeks later, I found the old folder while cleaning out the drawer, the edges worn, the tabs frayed, and I considered keeping it, then thought better of it, scanning what I needed, shredding the rest, feeding pages into the machine one by one, listening to the steady grind as months of pressure reduced to strips of paper that no longer held power. I kept the final order, filed neatly, not out of fear but record, then closed the drawer. The next exchange happened smoothly, uneventfully, the supervisor nodding, checking boxes, my husband remaining silent, his compliance procedural rather than heartfelt, and for the first time, I felt the difference between silence that conceals and silence that acknowledges limits. Driving home afterward, I realized that the voice that had once filled the courtroom no longer echoed in my head, replaced by the hum of the road, the radio low, my own thoughts unchallenged. There was no dramatic release, no moment of triumph, just a gradual return of space, of choices made without anticipating someone else's interference. On a quiet Sunday morning, I sat on the porch with a cup of coffee, the sun warming the steps, and thought about how the judge had stopped the hearing because he recognized a voice that didn't belong where it claimed to be, how that interruption had rippled outward into everything that followed. It wasn't justice in the way people imagine it, loud and satisfying, but it was real, recorded, enforced, and it changed the direction of things in ways that mattered. I finished my coffee, stood, and went back inside, closing the door behind me, the sound solid and final, carrying with it the simple knowledge that my voice, my name, and my life were no longer available for someone else to use.